Submitted on argument this afternoon, National Automobile Dealers Association versus Federal Trade Commission. Mr. Harris.
Good afternoon. May it please the court. The rules at issue in this case will inject FTC-mandated disclosures into hundreds of millions of interactions between car dealerships and their customers. Even the FTC's flawed analysis acknowledges that this will be a billion-dollar rule. It was thus imperative for the FTC to turn square corners, follow the proper procedures, and ensure that these far-reaching new requirements were carefully studied and justified by the record. The FTC failed at each step. Starting with the procedural flaws, the FTC skipped a crucial step in the rulemaking process that's required by the unambiguous text of its own regulations. Section 1.10.
This isn't a Loper Bright. This isn't an agency that's grabbed an old law and putting it on a new problem. This is Congress saying, you've got to regulate the automobile dealers, correct? And the question, at least if we're looking at the advance notice issue and the cost benefit, your argument is sort of an introverted one, which is what Congress has said doesn't apply. Is that fair or not?
I would disagree where you said have got to. So you see statutes, and this is the Children's Online Protection Act, this is the TPPRA of 1992. You see statutes where Congress tells the FTC, you shall do a rule, you must do a rule, often with a deadline, and typically says by APA procedures. That is not at all what we have here. All we have is an authorization for the Commission to use APA procedures. But of course, as we know, the APA is a floor, not a ceiling, and countless cases have held that agencies are free to supplement those procedures as they deem appropriate.
If you're right and the law doesn't sort of court strip or remove advance notice, if you're right, it's still the errors you're pointing to would be subject to Shinesky harmlessness review, correct?
I agree with that, Your Honor. It is our burden, but it's also not a particularly demanding standard. It has to be, it basically has to be clear that there's no prejudice.
Are you going to start with the advance notice, or?
Yes, I would love to. So again, 1.10 is as unambiguous as text can be. Prior to the commencement of any trade regulation rule, the Commission must publish advance notice in the Federal Register. Any means all. And the only question is this a trade regulation rule? So we look at the title of both the NPRM and the final rule, say trade regulation rule. Now, the FTC, they point to this 1.7. That actually supports us because 1.7 says the rules in this subpart B will apply to the promulgation of rules as provided in 18A1B. Dodd-Frank explicitly says these are rules under, Dodd-Frank's words, A1B. So, and then it says that those rules shall be known as trade regulation rules.
So Dodd-Frank says no statutory advance notice, and this is a question, yes or no, FTC could have rescinded theirs by virtue of that, but they didn't. Is that the decisive fact?
That's our position. They could have, or they certainly could have initiated the process to do so, absolutely. But as Perez v. Mortgage Bankers in many cases make clear, an agency must rescind or amend its regulations the same way it passed them. These are notice and comment regulations. Again, they could have tried. And Your Honor, I think the 2021 rulemaking here is critical because this isn't just some dusty old thing sitting on the books. The FTC reopened these regulations precisely in order to remove things, their words, that were not statutorily required, that were inefficient, that they wanted to take off the books. So again, this isn't just, it's been sitting there since 1980 and all of a sudden we're trying to spring on them. They've reconsidered this.
Does the record show they made a deliberate choice to not accept Congress's dispensation?
I don't want to oversell the point. It doesn't say that. But there's no question the FTC fly-specced a lot of their 110 rules and didn't do anything with respect to this. And again, they had plenty of opportunities to do so. In the wake of Dodd-Frank, if they thought they needed to make changes to their own rules, that would have also been a good time to do it. So again, I think the Rotisky case of the Supreme Court, I think, makes very clear, one, the court should be skeptical of an interpretation when it's something Congress has done elsewhere but didn't do here. And the TDDRA, which is 15 U.S.C. 5711, and COPA, 15 U.S.C. 6502, the structure is so similar to each other but different from Dodd-Frank. So again, both of those, as we started off, said FTC shall or must do a regulation using APA within reasons. And then it says the final rules shall be treated as 18A1B rules. So it seems to say these aren't really 18A1B rules, but when you enforce it, in sections that typically say enforcement, we will treat them as 18A1B rules. That is, Dodd-Frank could not be more different. Dodd-Frank makes clear these are 18A1B rules. And I don't think that's just a philosophical question of what are they, because I think it does go to what triggers these procedures in 110, and it's being an 18A1B rule, or also known as a trade regulation rule. And just a few cases, I mean, again, I think if you look at...
there aren't many post-Dodd-Frank cases about advance notice, are there?
There aren't, no. And again, I think...
You cited, was it the Sixth Circuit, Wilson and Johnson? But that's in the context of harmlessness, correct?
Yes, and I think Accardi itself is pretty good. Accardi is a case about immigration, and the Supreme Court says the agency's procedural regulations supplant what it calls the bare bones of the statute. So we know the agency is going beyond the statute and holding that you have to follow those. And Morton v. Ruiz, similar thing in the tribal context, says, upholds some agency procedures about when to publish findings about Indian tribes. So, and then again, one more quote, Perez v. Mortgage Bankers, agencies are free to grant additional procedural rights in the exercise of their discretion. So again, this isn't Congress telling the FTC, use the APA. The APA is a floor. Congress tells them you're free, notwithstanding Section 18, and that's it. And again, I'm not here to opine on whether they could change that, but they haven't. And I think in the meantime, they have to turn square corners on this.
And their argument is, when we know from Congress, the plain language, they've supplanted that. They want to streamline and get the rules out so you don't get advance notice. You're saying, no, the two they haven't rescinded, therefore actually what Congress said doesn't apply.
Well, no, all we know that Congress did, and there's very little history or anything of it, because I think some of these were late changes to Dodd-Frank. Again, Congress lifted one statutory constraint and provided authorization to use some different procedures, and that's all we can infer from what the text says. So again, they haven't changed it or attempted to change this, so I'm not here to opine about that, but they...
If you're right, what circuit case do you have that vacates a final rule for lack of advance notice when the petitioner indisputably got notice, participated fully, here close to 200 pages, single space, in the final rule? In other words, this is shifting to harmlessness. Where's the prejudice?
I think the Backcountry case is pretty good, which we cite. It's out of the Ninth Circuit, but I don't think there's any difference.
Is it in the context of notice?
I'm sorry?
Is it in the context of notice?
Oh, yes. It's in. So there was some supplemental study or finding, and the parties never got notice of it. And so it was also kind of 2 rounds of stuff. And the court said, no, when there's multiple rounds of notice and comment, they use the term interactive process. And so, of course, it's prejudicial to not be given your ability to participate in this process. And another...
I mean, it really cuts the other way, doesn't it? The fact that they did submit a lot once they had notice means that they surely would have submitted more if they had advance notice. And there would have been an opportunity to make adjustments.
Absolutely. And the Johnson case, which my friends cite, Johnson it was just a binary switch. Does SORNA apply retroactively? And the petitioner, there was no indication he would have participated. And also the court noted, on the record, the retroactivity issue was obviously front and center. So there was no issue of unfair surprise. But here, and just to take a step back, one thing about the advance notice, which I think goes to both prejudice and why we needed it, one of the purposes of the advance notice is to determine if you need a rule in the first place. Because, of course, that's where, and we point to these 49 questions about these big picture things. How do states regulate this? How does the market work? one of the points of the advance notice is to develop a record on, do you need a rulemaking? This is where you're asking, what are the states doing? What's working well? What might not be working well?
Just so I can clarify, backcountry is an advance notice case.
No, it's not. And again, there's not a lot of advance notice requirements, but backcountry involved multiple
But I guess I'm
rounds
trying to follow the logic of, if you do get notice and you've got 60 or 80 days and you participate massively as your client did, in fact, the final rule reflects changes from it. What's the case that stands for, we're going to vacate the rule because you were harmed for lack of advance notice?
I think it's a pretty unique situation, but I would say this. If they're right about this argument that you just articulated,
Yeah.
they would be excused from doing it in the statutory context too, because every argument they would say about why we aren't prejudiced would apply if they just skipped the step in the statute. If they say, oh, plenty was in the NPRM, you had plenty of time, you already commented. So I think that proves too much to suggest that we...
Where in your brief do you point out what your clients would have said that they didn't get a chance to?
It's a little bit of a tough exercise because they didn't publish it. I mean, I think, or let me find the one.
But do you hazard any?
I'll give you one that I think we, so sorry, I want to make sure I get the language here. Question 49. What has been the experience in states that regulate auto sales, including with respect to add-ons? How have those regulations worked? So question 49 is literally asking for a 50-state survey about these very complicated products, and I think that's exactly the sort of research my clients would have been happy to commission. But again, we responded to the questions, we did the best we could, but I think there are limits in what you can do in that limited context. But again, I think question 49 is a pretty good one.
Good
Which is basically, it's asking for a 50-state survey.
Huge amount of work.
Yeah.
Okay. You want to move to the cost and benefit portion, or do you want to?
Sure. Unless the court has more questions on this, I'm happy to do so. So, we obviously broke up our brief a little bit, but these are all arbitrary and capricious arguments, and I think the key cases we're operating in the framework are Mexican Gulf fishing, which unequivocally says part of arbitrary and capricious is considering costs and benefits, and then Chamber of Commerce, which holds very similar things and says the agency didn't adequately account for its costs and benefits. So here's at a high level what we think went wrong. This is one of the most pervasively regulated industries in the United States at every single step of the transaction. What the FTC did was to say, some bad actors have done bad acts. These are just the tip of the iceberg. So we're going to airdrop in this whole new regulatory regime, a whole new apparatus of regulation, even though we've never tested it and we don't know if this will prevent the bad acts that have been happening. I mean, we don't dispute there's bad actors. There are 40 million covered car sales per year. Of course, it's a huge industry. There will be bad acts. But what we're missing is the link between these regulations, which I can't emphasize enough how burdensome these are on the industry, and preventing those bad acts.
But the issue before us here is, did Congress specifically strip circuit courts of the jurisdiction to review the estimations and calculations?
Right.
And you're saying they did, but there's residual APA review, yes? And you cite Abbott Labs, the 1967 Supreme Court decision.
That's a lot of it. I also think it's really important to underscore we're hearing different things from the FTC. So on authority, they say 110 doesn't apply because this is what they call a Dodd-Frank rule. They say it is, and pages 25 and 26 of their brief, they could not be more clear. This is not an 18A1B rule, it's a Dodd-Frank rule. The whole Section 22 argument turns on 18A1 as the trigger. So Section 22 only applies in 18A rulemakings, and so if this is a Dodd-Frank rule, again, I hope the court agrees with us and says they should do advance notice, but I just think there's a lot of tension from what you're hearing in the commission's brief on this.
I'm just drilling down on the Abbott
Yes.
Labs position, because there the court overturned the Third Circuit because Congress hadn't made its intent clear. Mm-hmm. But you're not saying Congress can't explicitly strip courts of jurisdiction over cost-benefit analysis, are you?
No, but I think if that C3 I think means anything, I'm not sure what it could mean other than arbitrary and capricious standard. I mean, it's saying it's preserving the standards for judicial review. So as I read, and I'm sorry, the cross references obviously don't match. I think this is called section 22. As I read that, it says we can't go to court and say the FTC didn't comply with section 22, but I view it as absolutely preserving general APA standards.
So what can circuit courts not review related to the cost-benefit analysis? What's left?
I'll be honest, I don't think there's much. But I think if this strips APA review, then there's nothing saved by the savings clause, because I don't know. So
Okay.
And I think here's how I would put it together. I think this provision goes back to 1980. It came in the 80 Act. And I think since that was passed, the courts have been much more specific, both this court and the Supreme Court, in terms of what APA arbitrary and capricious review looks like. And so, I don't know what was intended when it was enacted, but I think as we sit here today, when you look at Chamber of Commerce, when you look at Mexican Gulf fishing, cost benefit, or again, and it doesn't have to be mathematical cost benefit, but rational consideration of the costs and benefits is fundamental to judicial review. And
The amici cite the Judge Katz's decision in the D.C. Circuit, DCH. Are you familiar with that? Where he said, looks pretty clear, Congress has said, we don't second guess the Secretary's cost estimations.
yeah, again, I'm not sure.
Turns on the explicitness of the language. If the intent is indubitable, courts are out of the game.
Well, I'm not sure if that had a savings clause similar to ours, I guess I would say. And they cite a lot of cases where I think there was one saying that certain federal loan guarantees were incontestable. And again, in the cases they're citing, I don't disagree with them, but I don't think they have this backup, this savings clause.
Okay.
So, but I also want to be clear, Your Honor, on cost benefit, make no mistake, as we say in our brief and say at length in the comments, we think there are profound flaws with what we would call the cost-benefit analysis. But it goes, there's plenty we are challenging that is not necessarily limited to that. So for example, this question of have they adequately responded and considered pre-existing law? This is a pervasively regulated industry. That's also a cost-benefit issue, because if pre-existing law is preventing these bad acts, then this new regulatory regime will be very costly and have very little benefit. So I hope you agree with me on the litigation bar, but even if you don't, I do think there's a lot to our argument beyond just that. So turning to more of the core of the argument, the FTC never grapples with this inherent contradiction in its position, which is we hear again and again, transactions take too long, they're too complicated, there's too much paperwork, there's too much confusion, and their answer is to inject more disclosures and paperwork into hundreds of millions of interactions between dealers and their customers. And we don't dispute that it's well-intentioned, but as the people that actually have to implement this, and remember, with the record-keeping requirement, dealers are obligated under penalty of an unfair trade practice to keep records of their compliance with this rule, which means if there's a meeting, if you're on a test drive with the customer and you have to make a disclosure, if the customer texts you or the customer messages you through Facebook, how on earth is that dealer going to make the record to prove that they made the disclosure in the event the FTC comes knocking at some time? So
And the customer may have test-driven 10 vehicles.
Absolutely.
Or the customer may have said, well, okay, as to this vehicle, what if you add a certain new item, some add-on to the car, what's that going to cost? So it could be multiple disclosures for each vehicle.
Absolutely. And remember, too, with the monthly payment, it says each time a monthly payment is discussed, the dealer has to basically do the full underwriting and put in the full total of payments. But if I can talk about the Truth in Lending Act for a minute, because I think that goes to the heart of a lot of this.
The burdens you're talking about are paperwork. In other words, they're just transparency, key papers. This isn't, you got to comply with new carbon emission rules, you got to build solar panels. It's the dealers, you've got to have on paper what the item costs, what the extras are, right? So any regulated industry is going to have paperwork.
Well, it's also a matter of the timing. So here's the status quo. at least, let me take lending, because I think the Truth in Lending Act, which we talk about pretty extensively, is, I think, a good illustration of this. The Truth in Lending Act has been around for 50 years. It's implemented by the Fed, and I think CFPB now has parts, FTC has parts. This is how credit disclosures are made. The purpose of the Truth in Lending Act is to help consumers be informed and make decisions about credit. And everyone who's ever taken out a loan, before you complete the transaction, you get the packet, which has the amount being taken, the amount being financed, the APR, the down payment, the total of payments over the life of the loan.
But if they're already doing it, that would suggest they won't have that much cost for compliance, or this system is all duplicative.
It's adding on top of this. So the Truth in Lending Act simply says before the transaction is finalized, you have to make sure the consumer gets this, or of course the consumer could ask for it. But now, every time there's a discussion of the monthly payment, these are all going to have to come in. And respectfully, I just don't think they have justified layering all these new burdens atop a time-tested regime. And I do think, let me give you a quote too. This comes from their own, so they cite about 20 times this car buyer study, even though they say it's non-representative. This is what they say. In that study, any recommendations to change or add to the current disclosures would need to consider the effect on the duration of the transaction or the already large amount of paperwork to review. And so that's JA 26. It's their own study. And when you think about how this works on the ground, as dealers are making these disclosures, and again, the honest dealers that they claim to be concerned for, it's just going to be, here's your disclosure, please sign an initial. Here's your disclosure, please sign an initial. Here's your disclosure, please sign an initial. So I just don't think, when you look at this rule, that they've adequately grappled with these very serious questions of, will these disclosures solve the problems that they claim to be happening? And again, I think cost-benefit analysis sounds too formal, but I don't think they've explained why the upending transactions in this way will stop the handful of bad actors. And on this question, I do say, they cite statistics about complaints, they talk about enforcement actions. I mean, again, we don't dispute they're bad actors, but there's a big denominator problem here because there's 30-some million car sales that will be subject to this transaction. So I don't minimize, 30 enforcement actions, or, they say there's complaints, although we don't know what those are about. But even if all 100,000 complaints they cite were somehow about this, that's 0.3% of sales. So again, there's a big denominator problem.
It's not just the 30 million sales, it's however many millions of potential sales that were discussed with each customer.
That would be my view, right? And I think
Those weren't final sales.
Right, and in the cost-benefit analysis, I think that just sort of excludes those. It doesn't even count those for disclosures. And guess what?
But this argument is State Farm going to the underlying rationality.
Absolutely. Was there a connection between the facts found and the choice made? And I would also add...
Before your time runs out, though, I'd like to... Would you have a response to the amici brief by The Economist? Because I'll read to you, in terms of the cost-benefit analysis. Pursuant to the academic studies, the amici estimate the effect on the markups is likely to be much greater than the base scenario employed by FTC. So if the FTC says 13 billion savings, 1 billion costs, the economists are saying it's actually going to be bigger. The reduction in markups will more than offset the potential rise in prices due to potentially higher compliance costs borne by the dealers.
I don't agree with that. I mean, I think when you look at the deadweight loss analysis that the commission actually did, I don't know how they could assume. I mean, many of these are small businesses that run on pretty tight margins, and when you look at the deadweight loss analysis, they estimate about $1 billion of less deadweight, which almost exactly matches the $1 billion of compliance costs. So I just don't think, if there's ever a situation of failure to consider an important aspect of the problem, I would think, gee, what's the industry going to do with the $1 billion of costs you just put on it? So again, I think there's important pieces that are missing from this deadweight analysis. I also think there's another issue with this offering price, which is, we put this in our comments in our brief. It's 161 of the joint appendix and 44 of our brief. this offering price could also be affirmatively misleading, because now that the dealer has to go around offering price, disclosure, every car, this is the offering price, this is the offering price, this is the offering price. I believe as the rule is written, they intend it to be a ceiling, not a floor, and you can still negotiate down. We point out in our comments, and I'm not sure they actually have a great response, that many consumers might see this and think that it's now one price shopping and that's the price and you have to pay it, when in fact it's more of a ceiling. And so by anchoring so much to this new offering price, we actually think there's a very real risk that some consumers might think, oh, okay, that's it, we're done, and there's nothing further to negotiate.
All right, you've saved time for rebuttal, Mr.
5 minutes, yeah, thank you.
Mr. Aiken?
May it please the Court, Ben Aiken on behalf of the Federal Trade Commission. In Dodd-Frank, Congress authorized the FTC to issue rules to combat unfair or deceptive acts or practices by car dealers through ordinary notice and comment rulemaking. The Commission properly exercised that authority to address two of the most egregious and persistent practices in the motor vehicle industry: bait-and-switch tactics and hidden fees. These practices harm both military and civilian consumers and also hurt honest dealers. Dodd-Frank expressly excused the Commission from following the additional procedures in Section 18 of the FTC Act, including issuing an ANPRM. NADA's argument that the Commission imposed upon itself an independent obligation to publish an ANPRM is inconsistent with the text, structure, and history of the relevant regulations and with Dodd-Frank.
Well, they're not saying they imposed it on itself after. They're saying it always existed and FTC didn't choose to rescind it, create it, so you overlooked a parallel structure you're now stuck with.
That is what they're arguing, Your Honor, but it is inconsistent with the text, the structure, and the history of those regulations. And as we said in our brief, and I didn't hear my friend on the other side discuss it all, Section 1.21 of our rules of practice is the key provision here. That provision sets forth the scope of Subpart C of our regulations. And it says this subpart sets forth procedures for the promulgation of rules under authority other than Section 18A1B of the FTC Act. Now, when my friend on the other side was up here before, I heard him describe Dodd-Frank as providing authorization to the FTC to use the APA. Dodd-Frank is an authority other than Section 18A1B of the FTC Act, and because it is an authority other than Section 18A1B of the FTC Act, Subpart C of our rules apply. And Subpart C makes clear that this subpart does not apply to the rules, for the promulgation of rules as governed in Subpart B. So when we look at the two subparts in conjunction with each other, when we consider the structure of the regulations, it becomes clear that these are mutually exclusive alternatives. The final sentence in in Section 1.7 of our rules says that this subpart, that all other rulemaking proceedings will be governed by Subpart C, and the final sentence of 1.21 says that this subpart does not govern proceedings for Subpart B. So it's either or. And because we have an authority other than Section 18A1B of the FTC Act for this rule, Subpart C is what applies. That approach
If the authority were the section they're pointing to, Subpart B, would the argument, the argument that Congress has said you don't need to provide advance notice not apply?
If that were our only authority for the rule, Section 18A1B, we would have had to issue an ANPRM because we could only promulgate such a rule. In fact, that's how we did promulgate the used car rule in 1984 in conjunction with Subpart B of our rules. However, when we promulgated the amendment to the used car rule, because Dodd-Frank had granted us authority to regulate motor vehicle dealers consistent with the APA, we did not issue an ANPRM. We followed Subpart C of our rules. And that brings me to the next point. I mentioned the text and the structure of our regulations. The history is also consistent with this approach. Every time Congress has allowed us to use the APA to promulgate a rule, that's what we have done. So we did so in the used car rule. We did so in the Made in the USA labeling rule. We did so in COPPA, which my friend on the other side mentioned, and we lay all this out in the statement of basis and purpose in the rule as well. So the text, the structure, and the history all support the FTC's approach here.
But subpart C can't apply because subpart C applies to the promulgation of rules under authority other than 18A1B, and this rule was promulgated under 18A1B. So it's got to be encompassed by subpart B rather than C.
So Dodd-Frank says that a rule promulgated in accordance with the APA is still a rule under Section 18A1B, but Dodd-Frank is an authority other than Section 18A1B, and it's the authority we invoked when we promulgated the rule. So in Dodd-Frank's words, it says the FTC is authorized to prescribe rules under Sections 5 and 18A1B of the FTC Act. So Dodd-Frank is an authority other than Section 18A1B that allows us to proceed with this approach. And because it is an authority other than Section 18A1B, subpart C of our rules applied.
These are intricate rules. Do you have a case to support what you've just said? Has any case looked at this?
I'm not aware of any case that has construed 1.7 versus 1.21. As I mentioned before, this is consistent with the FTC's historical practice. As we point out in our brief, it's also consistent with the statement of basis and purpose that implemented these rules in the first place. So in Section 1.10 or 1.10 of our rules of practice was implemented in 1981, I believe, we were quite clear that the reason we were enacting that provision was to implement the recent changes to Section 18 of the FTC Act, which created the ANPRM requirement. This court has said repeatedly that when it goes to construe regulations, it considers the purpose of those regulations and does not seek to thwart or undermine the purpose of those
Is there any relevant legislative history for when Congress put this under the auto dealers under your authority that speaks to streamlining and getting out of the regular APA world?
I'm not aware of any legislative history in Dodd-Frank. I think we all know the history of Dodd-Frank was a confused and hurried one, but I think the plain text of Dodd-Frank speaks quite clearly. There's no reason for 5519D to exist except to excuse the FTC from having to follow the more complicated procedures in Section 18 over and above what the APA otherwise requires. Section 18B, in fact, incorporates the APA, Section 18B of the FTC Act. It says that the Commission has to follow Section 553 of the APA, and then it lists the additional procedures that we have to follow. So when Congress said in Dodd-Frank that notwithstanding Section 18 of the FTC Act, the FTC is authorized to prescribe rules under Section 18A1B in accordance with Section 553 of Title V, what Congress was doing was excusing us from all that in addition to that is in Section 18B of the FTC Act. Otherwise, it would be superfluous. The FTC already had the authority to promulgate a rule regulating motor vehicle dealers under Section 18A1B. Again, that's what we invoked when we passed the used car rule, or when we made the used car rule in 1984. The only reason that this provision exists in Dodd-Frank is to excuse the FTC from having to use those Section 18 procedures here. Judge Higginson, as you were asking my friend on the other side, even if the FTC should have issued an ANPRM here, that error would have been harmless. The Supreme Court and this court have been quite clear that the burden to show prejudicial error falls on the petitioner, on the party that is attacking the agency action. Both the APA and the FTC Act itself also instruct the court to take due account of the rule of prejudicial error. As this court held in Johnson, even the lack of notice of a notice and comment period can constitute harmless error.
But as Mr. Harris pointed out to us, if there had been an ANPRM, that might have pointed out to the agency that there was no need for a rule at all, or at least that there was a need only for a less sweeping or less comprehensive rule.
So two responses to that, Your Honor. First of all, on this record, that argument simply doesn't hold up. Back in 2011, the FTC issued a Federal Register notice. That's the very first document in the administrative record here, starting on A1. And on page A3 of that document, the Commission said that we were considering a rulemaking. So NADA had noticed for more than 10 years before we engaged in this rulemaking procedure that the FTC was considering a rulemaking. The NADA participated in those roundtables. NADA submitted comments. And then, of course, NADA made all these exact same arguments that there's no need for a rule here, that there's already an existing regulatory framework in its response to the NPRM. So that is simply not a source of prejudice from the lack of an advance notice here.
What was your argument, though? Wouldn't it make it the advance notice toothless any time a regulated entity got actual notice and then contributed its comments? It would always render an advance notice provision harmless or not?
No, of course not, Your Honor. It's always possible a party would be able to show some source of harm. I hesitate to put words into NADA's mouth. What stands out here is in their brief, they deny that there's any need for them to show prejudice here. They say the rule of harmless error does not apply. And they don't make a single argument, including the one that they've raised here at oral argument. That is not in their briefs. There's nothing in the harmless error section of their brief, in either their opening brief or the reply brief, that explains the source of the prejudice here.
Are you familiar with our Wages and White Line case pending in front of the Supreme Court?
I'm not familiar with that case, Your Honor.
There's some possibility that our court, obviously subject to review of the Supreme Court, said once you knock out a procedural error, it's very hard to assess prejudice.
I would grant that it might be difficult because we're considering a counterfactual where that procedure existed. The key takeaway is that the rule still exists. Again, the plain text of the APA and the FTC Act both require some showing of prejudicial error. It says the court must take due account of the rule of prejudicial error. And NADA simply refuses to even try to identify any source of prejudice. And again, in Johnson, this court said, you have to show something. You have to make an argument about why there's prejudicial error here. That's what NADA has.
They say they had a big report and it missed the deadline.
So notably, they do not cite that report as a source of prejudice. And the reason for that is that the report responds to the NPRM. It purports to evaluate the effects of the provisions in the NPRM. An ANPRM is not a proposed rule. The requirements of an ANPRM are very bare bones. The commission must provide a brief description of the area of inquiry. It has to propose I'm losing my train of thought. It has to propose the alternatives it might be considering. It does not have to propose the actual provisions it's considering. So the study they commissioned could not have responded to an ANPRM. The ANPRM does not have to
True, but what happened to the study? FTC just said, well, we aren't going to read that?
No, not at all, Your Honor. At the very end of the statement of basis and purpose, there's a lengthy discussion of the study. The commission did consider the study, even though it was submitted out of time. The commission explained that the questions in that study were quite leading and that the sample size was very small and that there was no explanation as to how NADA had selected the sample. So the commission did consider the study. It just found it non-persuasive. If there are no further questions about either harmless error or about the commission's regulations, I'll turn to the cost-benefit analysis. So turning first to Section 22, C1, which does preclude judicial review of the cost-benefit analysis, there was some discussion with my friend over on the other side about what exactly Section 22 is precluding the court from considering. The answer is quite straightforward. Section 22 precludes the court from considering the Section 22 final regulatory analysis. Section 22 provides exactly what that final regulatory analysis must include. Among those provisions in 22B2C, it says that the commission must consider the projected benefits and any adverse economic effects of the rule. That is exactly what we did, and that is exactly what NADA attacks at the end of its brief. It is going straight for the economic analysis in the commission's Section 22 final regulatory analysis. Every single page that NADA cites in the cost-benefit, and I'm talking about the Roman numeral 3, I suppose, of their opening brief, in the cost-benefit section of their brief, every single section they cite is part of that Section 22 final regulatory analysis. And Section 22 says the court cannot consider the contents and adequacy of that analysis. NADA has no explanation for how a court could possibly review for arbitrary and capriciousness without considering the contents and adequacy of that analysis. There is, to be clear, there is...
What's the legislative history to that? In other words, is that because Congress realized these cases are coming to circuit courts, we're not courts of first view, so we actually can't even solicit expert view on economic matters?
I'm not aware of the legislative history of Section 22. there is some background there where Congress was sort of imposing this additional requirement on the FTC to make sure that when we did issue a rule that we carefully considered the benefits and costs of the rule. And
But who enforces that?
who enforces the fact that
That you do a careful cost-benefit analysis rather than a cavalier one.
nobody enforces it, Your Honor. That's the trade-off that Congress made. When
What if you didn't do one at all? In
So-
other words, I mean, my concern is that when I read the APA, it's pretty much all about giving American businesses the opportunity to complain and say, you haven't thought of how burdensome this is going to be. That's what it's really about. And you're not denying, you're saying you thoroughly looked at those. But what if the FTC said, wow, Section 22, we don't even need to do anything because we can't be reviewed? Am I oversimplifying it?
You're not, Your Honor. There's two responses to that. First, in Section 22C1, which is the judicial review provision,
Yeah.
the final sentence of that says that the court may set aside such a rule if the commission has failed entirely to prepare a regulatory analysis. So certainly if we just don't do it, the court can absolutely vacate for that reason. Beyond that, I would note the only thing that is precluded here is our Section 22 final regulatory analysis. That makes up about 21 of the 100 pages of this rule. Anything left is fair game. That's not part of our Section 22.
I think you're overlooking, or I think your brief overlooked an entire sentence of Section 22 that says that its provisions of Section 22 do not alter the substantive or procedural standards otherwise applicable to judicial review of any action by the Commission, close quote. In other words, although courts can't review compliance with the requirements of Section 22, they can, in fact, they would be required to review agency action for compliance with the APA.
So two responses to that, Your Honor. First, the key word there is otherwise, and so Your Honor is referring to Section 22C3. It says the provisions of this subsection do not alter the substantive or procedural standards otherwise applicable to judicial review of any action by the Commission. So as used here, Congress was saying that while the court cannot review the contents and adequacy of the Section 22 final regulatory analysis, it can still review other aspects of the agency's commission. And to be clear, our position is the court can review the rest of the rule. And there are 80 pages left of this rule. I would especially point the court to the section-by-section analysis in the rule, which is the bulk of the rule. There's plenty of analysis in there about the trade-offs in this rule, which are the costs and benefits of the rule. That is not part of the Section 22 final regulatory analysis. But I think the best way to understand—
You said you had two answers.
Yeah, sorry, that was the second answer. So the first answer is this otherwise. So we do have to take what's in Section 22, the final regulatory analysis, as unreviewable. So what the Commission has evaluated there about the costs and benefits, the court needs to start from the position that that is unreviewable, that what the Commission has calculated the costs and benefits to be, at least economically speaking, is correct. But the second part to Judge Smith's question, we are not trying to insulate any discussion of cost and benefits throughout this rule. There are another 80 pages of this rule. A lot of that content comes in the section-by-section analysis, where we do discuss various costs and benefits to different provisions. Commenters wrote in either encouraging us to adopt more rigorous regulations or looser regulations, including NADA, but also including industry groups. And at times we discussed the benefits of those proposals or the cost of those proposals. In fact, there's instances where we rejected a proposal because we'd said that would be too costly. It would require too much disclosure. It would require too much paperwork. That's all fair game. The court can consider that. What the court cannot consider is attacks and challenges to the Section 22 final regulatory analysis. And again, every single argument that they raise in their brief, in both their opening brief and in the reply brief, about the cost-benefit analysis cites directly to that Section 22 final regulatory analysis. To put it in terms of this argument, we do not dispute, for instance, that the court can consider the arguments that NADA has raised about the widespread nature of the problem or about the regulatory gap that the rule either fills or does not fill. That's fair game. That's part of arbitrary and capricious review. And I'm happy to turn to those arguments next if the court has no further questions about Section 22.
No, I'll stick with the costs and the benefits.
Sure.
A little bit. If we were to review it, of course, this would also be reviewed for harmlessness.
That's correct, Your Honor.
And let's go into that a little bit. In other words, what relevance or weight can I give to the amici economists that say that the FTC actually underestimated the benefits?
You can give plenty of weight to that. Well, let me put it this way, Your Honor.
And also, and they do make it's sort of a more simplistic, but it attaches to the head in terms of how'd you peg a 3-hour savings with reference to the digital experience? Can you address both?
Sure. So two different parts there, Your Honor. First, as to the economist, the rule itself makes similar statements along the way. So throughout the statement of basis and purpose, there are references to why the commission made certain choices that it did. And the commission often explained that it was choosing the more conservative estimate for different costs and benefits. So when the economists come forward and say, actually, the benefits are far greater, that's completely consistent with some of the findings that the commission made. It's also consistent with some of the sensitivity analysis in that Section 22 final
Stress tests.
Yes, exactly, the stress test. So the commission, while it has a base case for what it believes the costs and benefits will be, it also said, well, what happens if we're underestimating, and what happens if we're overestimating? And under any of those variables, the costs of this rule the benefits of this rule greatly outweigh the costs of the rule. Your Honor also asked about the time savings that come from looking to the experience of digital users. So first, just to be clear, Your Honor referenced the 3 hours time savings, which NADA does mention that in their opening brief. As we explain in our response brief, we abandoned we think that the 3 hours was still reasonable, but is no longer the hook we're using. That was in the NPRM. The final rule settles on approximately 2.05 hours of time savings. And again, it does stress test that too. So it says a low estimate about 1 hour and a higher end estimate about 3.3 hours. We do arrive at that by looking to the experience of digital consumers. But to be clear, the commission did not say that the entire process is going to mimic the experience of digital consumers. We pointed to specific aspects of time savings that digital consumers enjoy. So for instance, time saved traveling to the dealer. NADA says that you're still going to have to travel to the dealer. But what NADA overlooks is that the rule explains consumers often travel to multiple dealers, and the reason they do is because of the classic bait and switch tactics that this rule addresses. They see an advertised price, and they believe that they can acquire the vehicle for that advertised price. They travel to the dealer only to discover that either that vehicle is not available, that price is not available, or neither are available. So they have now wasted time traveling to a dealer in pursuit of a transaction that they cannot get. That happens multiple times during the car buying process. By requiring upfront, honest disclosures, including in advertisements, the rule will save consumers trips to the dealer. The rule also flags time saved during the negotiation process. Again, this is something that digital consumers enjoy, and the rule looks to that as a source of time savings. And I think we've all been there. You go to a dealership, you sit down in the dealer to negotiate, and the dealer gets up and walks to the back room to talk to the manager. That is time that you have wasted during the negotiation process that digital consumers do not waste. They can just do that by email while they're sitting in their kitchen, while they're upstairs playing with their kids. They don't have to wait there during this back and forth.
One of the things that Mr. Harris pointed out is that he sees the final price that has to be quoted as a ceiling, but that there could be negotiations below that. So in any of these transactions, if he's right about that, and you can tell us whether you think he is, then there's still going to be negotiation. There's the flat price is quoted, and then the customer says, well, can we adjust that? Will you accept so-and-so? Can we adjust the terms of payment or whatever? Can we do add-ons? So there's continuing negotiation, not just a flat price.
So he is correct that the offering price disclosure sets a ceiling, not a floor. The dealer has to advertise or in the first written communication about a specific vehicle, tell the consumer what the actual price for which they can purchase the vehicle is. That's all it requires. They are allowed to negotiate down from there. But again, digital consumers enjoy a similar experience. They can email these negotiations. They can go back and forth. The conversation now starts with an actual honest offering price. That is not the current world. Under the current world, as we documented, as we learned through our enforcement actions, as commenters explained, they go in, they start negotiations. Many times they spend hours negotiating. They even might think that they have a deal only to learn that is not actually a deal. That is not the price for which I can purchase this car. In reality, there's another $1,500 delivery fee. There's another $800 dealer fee. There's another $600 because there's some add-on on this car that we never discussed. By requiring upfront disclosures, the rule ensures that the conversation begins at a price that the consumer can actually purchase the car for.
That's on the savings side. I know you want to get to other issues, but on the cost side alone, was there anything that NADA said that related to excessive costs that the final rule then did say, you're right, we'll take that out?
I don't
On
remember.
your brief, page 1867, you twice mentioned that the final rule did respond to some of their cost concerns.
I'm looking over my I think that is correct, Your Honor. I know, for instance, that the 3-hour time savings is one of those. NADA did say that those 3-hour time savings were just pulled from thin air, and we did adjust from there. We looked at the Cox Automotive study as a source for time savings, and we adjusted down from there. I believe
I'm
they're...
less concerned about the benefit side savings. I'm worried about the paperwork side.
Oh, I see. Yeah. So one example was the add-on list. So one of the proposed provisions was that for any transaction, the dealer would actually have to list all the available add-ons and would have to get the consumer to expressly say whether they did or did not want that specific add-on in the price. We ultimately determined that was just too much. It required too much paperwork and too much time, and so we withdrew that provision. There are some other provisions we withdrew too. For instance, we narrowed the scope of the rule. We made clear that it only applies to motor vehicles. It doesn't apply to, for instance, boats or electric vehicles. And there were a few other provisions also that...
Doesn't apply to electric vehicles.
Excuse me, electric bikes. It does apply to electric vehicles. My apologies, Your Honor. Yes, so there absolutely were provisions in the proposed rule that we ultimately did not adopt because we determined that the costs were too excessive. Finally, as to the existing regulatory landscape, I think the basic point there is that all the problems that the Commission documented, over 100,000 complaints a year in each of the 4 years leading up to the rule, the dozens of enforcement actions over the course of 10 years preceding the rule, all of those occurred against the backdrop of the existing regulatory landscape. That includes the TILA, that includes the CLA, that includes state laws banning some of these practices. So the Commission ultimately determined that a rule was needed. What a rule does is it allows the Commission to seek both civil penalties and consumer redress, which the Commission currently cannot pursue solely under its enforcement authority. I would also point out that the Commission did, throughout the rule, consider the existing regulatory landscape. It did consider the TILA and the CLA. We did so at pages A433 to 34, at A441, at A470 to 71, and at A478. Numerous commenters, especially NADA, commented about the current regulatory landscape, about the TILA and the CLA.
How long did it take for the law to be settled on the TILA? My recollection, I haven't gone back and checked it, it was probably somewhere between 10 and 20 years, wasn't it, before all of the case law had been developed about how to interpret the TILA? That must have incurred incredible compliance costs, work by lawyers and accountants and lots of other people, not to mention company executives. You're going to face the same problem here in terms of regulatory costs, which goes to cost benefit, among other things.
So I don't know off the top of my head how long.
It went on forever.
I certainly take Your Honor's word for it that it took some time to settle on some of the meanings there. We don't deny that there are compliance costs here. The Commission found that there would be $1.1 billion in compliance costs to motor vehicle dealers. And again, we stress tested that. There's a sensitivity analysis that asks, well, what happened if we've underestimated those costs? What happens if we overestimate the costs? The Commission still concluded that the benefits of the rule outweighed the costs. That brings me to another point where NADA says that the Commission never considered the higher stakes of the rule. Now, one response to that is by acknowledging that there are higher stakes, is sort of a self-defeating argument about the existing regulatory landscape, because the higher stakes are the Commission's ability to pursue civil penalties and to pursue consumer redress. That is a current gap in the existing regulatory scheme. That is why we think that there are so many consumer complaints year to year. The higher stakes that dealers are now worried about is that the FTC will now have more authority to seek consumer redress. But in any event, the commission did consider those higher stakes. And while we don't believe that this is judicially reviewable, should the court look to the Section 22 final regulatory analysis, you can see it, I believe it's at page A520 of the Statement of Basis and Purpose. The commission considers an alternative scenario where dealers take on more than they need to, more than the commission has assumed that they will, in order to comply with the rule because of the rule's higher stakes. So that is all part of the commission's analysis. The commission still concluded that the benefits of the rule would outweigh the costs. If the court has no further questions, we ask that the petition for review be denied.
Thank you, Mr. Aiken. Mr. Harris for rebuttal.
Just a couple quick points, Your Honor. I'll try to take these in reverse order. So on monetary penalties, I just want to make clear that we have yet another inconsistency in the FTC's position, because monetary penalties, the cross-references are complicated, but we talk about this at our reply brief, I believe we're on pages 8 to 10. Monetary penalties are available for violations of Section 18A1B rules. And so this all just goes back to the question of what is this rule? If it is a Dodd-Frank rule, I don't see any authorization for monetary penalties for Dodd-Frank rules. So it can't be both. It has to be one or the other. And again, I would just underscore, again, the rule has to be something. And if it is an 18A1B rule, we need it in ANPRM. And if it's a Dodd-Frank rule, I don't see how there can be monetary penalties. It's in pages 7 to 10 of our reply brief, around there, where we walk through those cross-references. Now, one interesting thing my friend mentioned, he mentioned the fact that the final rule excluded some types of dealers that were in the NPRM. So this is boats, RVs, motorcycles. Do you know why? This is page 607 of the rule. The commission said we don't need to include these because no dealer may misrepresent material terms, deceive consumers about prices, deceive about add-ons, charge for products that provide no benefit, or charge without informed consent. So the commission literally said we don't need to regulate those other types of dealers because existing law was adequate to protect that. So I would say, why not the same here? The Economists, it's an interesting brief. I think the one thing I would point out about that, I'm not sure if they filed comments, so there might be a Chenery issue, but unsurprisingly for economists, it is a theoretical brief. I don't see any engagement there with the practicalities of how many times are these disclosures made? Are these disclosures going to slow down the transactions? In a perfect world where we could just say we have transparent pricing, that maybe they're correct, that these frictions would disappear and transactions become seamless, but I just don't see them really engaging with the practicalities of how will this work.
You had an alternative argument saying remand without vacatur, or?
We do present that as a middle ground. It's expressly in the statute.
They would still say it's expressly forbidden by Section 22.
Right, and we would say, again, I think we're
back into that.
We're back there, but I would say, again, if the court isn't willing to say it is arbitrary and capricious, I do think if the court believes there are gaps in the record that would inform whether the rule should stay or go, that is a middle ground that's available. Again,
with the stay in place?
the stay says they self-stayed pending judicial review, so I believe that would be the case. But then the court would...
If you just had to pick one biggest gap, it would be, in other words, where is the hard look needed most? There wasn't sufficient clarity. I know there are a lot. You think there are a lot.
I mean, under the broad rubric of, I think the Judge Smith mentioned TILA. I think it's just how on earth will this make things better compared to pre-existing law? This is a pervasively regulated industry.
Okay, but that's a State Farm argument. That's
Absolutely.
not, okay, that's not going to
that's
cost
not.
a benefit.
That goes to the heart of the rule.
Yes, it does.
Yeah. And then and I'll just say also, my friends, they said, correctly, they've sort of walked away from this 3-hour assumption in the benefits, which we said was pulled out of thin air. The new one is no better. What they did is all of these scary numbers of $12 to $14 billion of benefits, they took a study from 2017, the Cox study, and said people who go to the dealer spend more time than people who shop online. They then assumed that 82 minutes of that difference would be eliminated if we do these rules. So it's not, and then from there it's just arithmetic to map it all out. So it's not these very large benefit numbers where they say the benefits will swamp the cost, they don't have anything other than ipse dixit. The last thing I'll say in my last 45 seconds, our clients fully support transparency. And there's many things in these rules that at a high level, we want transactions to be efficient. We want to use less labor costs to be finishing the transactions. But the way the commission did this, it's difficult to overstate the burden this would impose on the industry to be papering up every single transaction with many new disclosures. They've never been tested. They've never been tried. We don't know if they'll actually work. And again, to quote the Commission's own 2020 car buyer study, we just don't know, and they have not shown that these disclosures will make things better instead of just compounding these problems of paperwork and slow transactions.
All right, thank you.
Thank you.
Mr. Harris. Your case is under submission and the court is in recess.